hope my internet connection is stable. I'm showing all of the bars, but you've been coming a little bit in and out. So uh, if there's a problem hearing me, please obviously let me know as best you can. May I screen share, Your Honor?
I'll give you 1 second, sure. Go ahead, Mr. Slim.
Yes, sir. This is it. Let me go to, this is the motion, Your Honor. Let me go to, sorry for dizzying you on this. My client is a lady named Sandra Salinas. She is living out her American dream by opening a Tex-Mex restaurant in the Irving Mall. In doing so, she signed a contract with ACERTS, a general contractor, to do the finish out. He was, per the contract, to provide a turnkey restaurant within 2 months for $175,000. He failed to do so, Your Honor. She had to take over the project, hire her own people to get it done, and it took months and months longer. Of course, she has a counterclaim on file for that. The contract provides that in the event of a change, change order rules will apply. I'm circling that right here. And then we go down to the change order rules. All change orders must be in writing. And again, must be in writing and agreed. All right, so we have a $175,000 contract, a 2-month finish date, which should be around February or April of 2022. Now, he files a lien in December 2022, but I don't want to jump ahead too far. But in May, now, can you read that? It's kind of small. I don't, oh, I can't expand it. Never mind.
There you are.
On May 22, 2022, he sends an invoice with a breakdown, and you'll see here electrical $95,000. The total jumps from $175,000 to $425,000 inexplicably. I have not seen any agreed to change orders. We go to his calculation. This is all in his demand. ACERTS, a fellow named Con Meyer. And we see the $425,000 number here, plus some extra charges for fees and whatnot. And they acknowledge, ACERTS acknowledges receiving $105,000 from the client. So per the contract, there would only be $70,000 due. But he's asserting $330,000 due as of May 2022.
Okay.
That's a critical date because he filed a mechanics lien. Can you hear me?
Yeah.
He filed a mechanics lien. He filed a mechanics lien December 22, 2022. Now, the statute says you have till the 15th day after the 4th month to file your mechanics lien. He files it for $332,546.90. $2,000 discrepancy. Maybe that's a collection cost. Maybe it's interest. But nonetheless, almost to the penny, what his May claim was. Now, when you count 4 months for May, June, July, August, September, 15 days of the 15th of the next month is October 15th. This wasn't filed until 2 months.
Mr. Slim, you cut out there. You need to, Mr. Slim, you cut out there. You need to repeat whatever you said. You're having some internet issues.
I'm sorry about that. What's the last thing you heard?
Tony. It was just like one sentence.
I'm sorry.
Mr. Slim, just explain the timing again. I think that's what you were talking about.
Oh, okay. Very good. From May 22, 2022, May 22nd, 2022, you have 4 months, and you have the 15th day after 4 months to file your mechanics lien. That's your statutory deadline. So for May, you got June, July, August, September. There's your 4 months. The 15th day of the next month is October 15th. That's the deadline to file the mechanics lien. We see that it's filed December 22, over 2 months late. We see in his affidavit, he states the facts disclosed are true within his personal knowledge. This is a public record. Texas law is very well established that when you file a public record, you are stopped to deny the contents of that record, the truth of the contents in that record. It preserves the integrity of our public filing system. That number 332-946-90 is almost identical to the 330-546-90 we saw in the May demand. Now let's go to their response. They responded and said, wait a minute. On September 25th, 2022, there was an invoice for electrical of $12,500. Your Honor, that $12,500 obviously was not included in the May calculation if it was indeed incurred in September, but it also wasn't included in the December calculation that was filed under oath with the real property records. I submit to you, Your Honor, that this is a sham affidavit. And here's why I believe it's a sham affidavit. They're alleging that this work was done by some company called Turn the Lights On with a Rockwall address and a 9960 phone number as of September 25th, 2022. And they say it under oath. Meyer Khan says it, and this fella who supposedly owns this company, a guy named Hussam Manawar, says it as well. However, we look to, let's see, it's blocking me. I'm up at the top of my screen. It's not letting me hit the tab. There it is. Got it. In their disclosures, which they filed just a few months ago, served just a few months ago, the electrician is somebody named Ibrahim Muhammad with a different city and a different phone number. And meanwhile, the calculation as of just this summer is, I'm sorry, let me get to that. There it is, $332,546.90. It's always been that number according to them. And it is only once I filed this motion to release this lien that they come up with this $12,500 invoice with no proof of payment, nothing other than the invoice and an affidavit that says here it is invoiced and the work was done. So I believe it's a sham affidavit. Now they've since supplemented, once I brought this to their attention, they've supplemented their disclosure and changed these numbers around. I understand that. People can supplement. Sometimes numbers can be a moving target. Totally understandable. What's not understandable is that as of December 22, 2022, that September invoice would have been known and accounted for. It would have been reflected in the lien amount. But we see, in fact, that the lien amount is consistent with the May demand. The September lien doesn't exist anywhere other than in this response, which was just filed a couple of days ago. So not only is there a blatant breach of the contract, that the price over doubled about 2.5 times that there's no written agreed change orders, that he didn't complete the work within the 2 months. And I'll point out something else that you might find interesting, Your Honor. When we go back to the contract, it says right at the top, work will be performed on a daily basis, Your Honor, meaning he's got to hump it. He's got to show up every day and he's got to do his work and meet this 2-month deadline. Every breach of contract imaginable happened here. Irving Mall has threatened my client. They have asserted a default under the lease because of this lien. The lease, as you can imagine, states that you can't have any mechanics liens out there. Yet 250% later, acknowledging that she paid $105,000 of $175,000 contract, they're just holding her hostage. It's going to be almost impossible for her to bond around. And we're looking to you, Your Honor, for relief to invalidate this lien as unenforceable and invalid under the Texas Property Code. Thank you, Your Honor.
Response?
Your Honor, opposing counsel made a really good jury argument, but a lot of what he said is totally irrelevant to the law that's applicable to this matter. If you look in his motion and our response, you will find the only thing that's relevant is whether or not my client performed work within the 15th day of the fourth, or filed its lien within the 15th day of the fourth month, which in the last month it performed work. One of the things he really admits is that we filed an amended petition and a lien release, reducing the lien amount to $197,500. We did this prior to the hearing. And what we found as we were preparing for the response to this motion is that my client is not entitled to his actual costs, which are $425,000 or so on this. If you look at the contract, it actually calls for him to be paid $35 per square foot for his work on the case. As a result, he is entitled only at this point, after accounting for the $105,000 payment by opposing counsel, to $197,500. That's why we filed the lien release and the amended petition. If you look at the affidavit of my client and the affidavit of his electrician, and I can assure you he's a real guy. I spoke with him on the phone myself. I provided his birthday in the affidavit. He did perform work out there within the time period necessary to establish that my client's lien, filed in December 22nd of that year, is valid. So while I appreciate the passion that opposing counsel, brings to this matter, if you look clearly at the response that we filed, if you look at the lien release, reducing to the amount that is my client's only entitled to by the contract, and you look at the evidence provided with the response, 2 affidavits, with an invoice, with swearing that the work was performed, it was broken down into actually pretty substantial work, Your Honor, if you look at the response. It involved reworking the electric system after some input from the city of Irving on what needed to be changed. It included wiring and installing all the light fixtures provided by ACERTs. It included wiring and installing all power outlet receptacles for the restaurant. It included wiring and installing all circuits for the kitchen equipment and wiring the control for a vent hood. And, as this case goes forward, opposing counsel will have the opportunity to depose whoever he likes. He hasn't served requests for production on us or any written discovery, and he hasn't asked for any depositions up to this point. But we feel like that we have properly.
So remind me, under the Texas Property Code, if the lien, so the lien amount was excessive, right? Because it was supposed to be over 300,000 and it's 197,000.
Correct.
Does it invalidate the lien so that it should be taken out of the record, or how does that work under the statute?
No, Your Honor, what would happen is the initial lien is still on file with the county, but subsequent to that is the lien release, a partial lien release filed by ACERTs that makes it clear that it's dropping.
And that was filed with the county?
Yes, that was filed with the county, and it clearly states in the lien release, which is attached to our response. I encourage you to read it.
I've read your response, just so you know.
Thank you, sir.
I'm just trying to figure out how this all plays together.
Sure. The only amount that my client could claim a lien for now is 197,500 as reflected by filings in the real property records of
So,
Dallas.
so what I'm getting at, I guess, is the original amount that was timely filed was excessive. Does that invalidate the lien, or can you correct it later under the statute? That's what I'm trying to get at.
Yes, you can by filing a lien release that effectively reduces that lien amount. Yes.
All right, Mr. Slim, do you agree with that?
I don't know, Your Honor. I need to look at I'll do some research on that. And you've asked a good question I didn't anticipate, but if I find something interesting, I'll certainly let you know.
You know, whenever people who have a lien filed against them make partial payments, you know, a lien claimant is required to reduce its lien amount. That happens all the time by filing a partial release. And, you know, that's the same principle.
But is that what happened here? It sounded like the original lien amount was incorrect.
The original lien amount was excessive, but the work that was performed is legitimate. The amount was merely adjusted downward to the proper amount called for by the contract.
So Mr. Slim, just so it's clear, based on the argument I've heard so far and the briefing I've heard so far, I'm going to give you two choices. One, you can pass the hearing because my main issue is he admits that the original lien was excessive. Does that invalidate the lien, or can that be corrected in the statute? I'd never dealt with that issue. And so if you want to research that issue, but I do agree most of the argument you've made today is great jury argument. I just don't think it's relevant for this proceeding. And so, but it may be the situation where, you know, the lien should be struck because the original lien amount is excessive. I don't recall that under the code. And so if do you want me to just deny it, or do you want to pass the hearing?
No, let's pass. And I also want to bring up, though, they completely ignored the whole May issue, the May invoice being consistent with that lien. They've completely ignored the estoppel argument, the integrity of the filing system, et cetera, which I know is kind of snowballing into that. So when can we get reset right now? So give me a deadline so I can get that brief to you.
Sure.
And Your Honor, will we have a chance to respond to whatever they file? And
Yeah, absolutely. That makes perfect sense. So how about hey Rhonda, that November 20th date, that should be an open hearing date. It says here it's not open. That should be a date people can set hearings.
I'm sorry, Judge, what did you say?
November 20th. You and I talked about this. That's listed as people can't set hearings that date. I'm available to set hearings on November 20th.
Okay, so you want, okay, it's closed. Okay, you want me to go ahead and reopen that?
Reopen that for hearings.
Okay.
So how about November 20th? Are you guys going to be in town that
yes,
morning?
Your Honor.
Yeah, so go ahead and set that on November 20th at 10 o'clock.
And, you know, given that I need to read what he's going to say, can we have some sort of deadline for him to file his supplemental briefing?
Yeah, Mr. Slim, you're going to need to get your supplemental briefing on within 7 days, and then you'll have 7 days after that, Mr. Peel, to respond.
All right, so the 13th of November is Mr. Slim's deadline? 7 days
It'd be the 6th.
No. So
I would be
7 days from today.
Oh, okay, got it. Thank you.
He has to file by October 30th, and then you have to file your response by November 6th.
Got it.
Got it. Okay. October 30th is my deadline. And then, okay, that's just fine.
Mr. Peel, go ahead and get an order in on this.
I have to draft one up and I'll get it e-filed today, Your Honor.
And it needs to say at the beginning that this was heard on October 23rd, 2023. The defendant or plaintiff passed the hearing. The judge gave instruction, reset the hearing, and all the stuff we just discussed. Just put that into the order.
Yes, Your Honor, I will do that, Your Honor.
Okay, guys, have a great rest of your day.
Thank you, Your Honor.
Your Honor, nice seeing you.
Yeah, good to see you. All right, Mr. Guerrero, are you ready for the default?
Yes, Your Honor. And on this one, Your Honor, we also filed our client's affidavit on Friday. I saw a note. Yes.
Give me 1 second. I see on 10/11 you filed an affidavit. I don't see anything else.
We filed it. I have here on my notes on Friday, Your Honor, I'm not sure exactly what time, but I'm not sure, maybe it hasn't got into the court
It
yet.
could be it hasn't been accepted. Why don't you email Rhonda the affidavit and then Rhonda email it to me?
Okay.
And have you already submitted an order on this?
Let me check, Your Honor. And Your Honor, this
I
one,
see
I'm
that
looking
you
through.
did.
And I'm also looking through the file right now, Your Honor, and I see that we finally got a hold of these defendants and they're going to ask their insurance company to respond. We have a signed tender letter from them. From what it looks like on the file that we're gonna send to the adjuster today. I'm not sure if that, if you believe, Your Honor, that we should still, go with default judgment or wait to see if the insurance company will respond, because
Why
I'll
don't
reach
you
out
do
to
this?
them.
Why don't you call the insurance company right now? Let's get them on the phone. I agree. I don't want to avoid your coverage. And so
Let me do
why
that.
don't you get them on the phone?
Okay. I would do that, Judge.
Yeah, like do it right now if you
Yeah.
don't mind.
Thank you.
Rhonda, can you go through we have a bunch of scheduling conferences. Can you go through those and see how many of them actually?
Thank you for calling the Connect Insurance
Good.
Claims Department.
Did you try to call the adjuster?
Oh, I'm calling them now, Judge.
Okay, sorry.
Yeah, sorry.
You've reached the voicemail of Tanya Martinez with Connect Insurance. Please note I am in the office, however, away from my desk or on another call. Please leave me a detailed message to include your claim number, your telephone number, and the reason for your call, and I will give you a call back as soon as possible. Thank you so much for contacting Connect Insurance. I look forward to speaking to you.
Good morning. This is Attorney Rogelio Guerrero with Ben Abbott and Associates. I'm calling on claim number CCB01243923. I'm currently in a hearing with the judge on this case for a motion for default judgment and dismissal for warrant of prosecution. Judge asked me to get you on the phone so that you can appear via phone on the hearing. If you could please return my call at 972-739-2267. Thank you.
Mr. Guerrero, do you want to just
I would
set
already-
this to the afternoon maybe? Or
I'm sorry, Your Honor.
you want to reset this to the afternoon?
Please, Your Honor, if I may also see, because I see here the note that we have the signed tender letter, that way I can email it to them and in the meantime be trying to communicate with them to see if they'll get the answer found.
Okay, good. Yeah, go ahead and we'll reset this to 3 o'clock today and hopefully try to get the adjuster on the phone then.
Will do, Your Honor.
Rhonda, go ahead and
Thanks.
reset the default to 3 o'clock today.
Okay.
We have
Will it be the same link?
Same link, always the same link.
Okay.